Good afternoon, everyone. Thanks for joining us today for the August installment of the Clinical Conductor webinar series. My name is Tom Gaybrook, and I'll be your moderator for the webinar. Before we get started, there are a few housekeeping items I want to share with you. First, we'll be providing a copy of the presentation via email within 24 hours of the webinar ending. Please be sure to check the email you used to register for the webinar. Also, we will be doing a question and answer session at the end of the presentation, so please submit any questions you have at any time using the GoToWebinar questions box on the right side of your screen. Today's presentation is titled Contracts 101 and will be presented by Jill Schilbauer and Marilyn Schiegel of Pharmaseek and PFS Clinical respectively. Jill Schilbauer is the Director of Network Operations for Pharmaseek LLC, an investigative site network that collaborates with pharmaceutical companies and contract research organizations, matching them with qualified clinical investigative sites for participation in clinical trials. With over 17 years of leadership, supervision, and contracting experience, Jill is responsible for oversight of the network, including the evaluation of possible new sites and performance of existing sites. She also conducts contract and budget negotiations on behalf of Pharmaseek and manages the site selection and project manager teams. Attorney Wynn Scheigel is the Contracts and Compliance Manager at PFS Clinical, a company that offers administrative solutions for research. She has over 30 years of experience in the health insurance industry, including both commercial health insurance and the Medicare and TRICARE government benefits programs. Her areas of expertise include health plan operations, training, provider credentialing, health plan and benefits program laws and regulations, and coverage from the University of Wisconsin-Madison, and a JD from the University of Wisconsin School of Law. She is a member of the State Bar of Wisconsin and the Dane County Bar Association, and is a board member of the HIPAA Collaborative of Wisconsin. And with that, I'll turn it over to Jill and Marilyn.
Thank you, Tom, and on behalf of Marilyn and myself, I'd like to thank everyone for joining us today. Again, as Tom mentioned, if you have any questions throughout the presentation today, please be sure to type those into the question box, and hopefully at the end we will be able to answer everyone's questions. It's a pleasure to be with you today on behalf of Pharmaseek and PFS Clinical, and we hope that today we can provide you with a number of different pieces of information and tools that's going to help you in the future with regard to your contracting activities as you move forward. So today our objectives are to provide you with contracting tips for clinical trial agreements and to point out some of the risk areas that we here at Pharmaseek and PFS Clinical feel that the focus should be on for investigation studies that institutions and investigators are taking on. We also will be providing you with different ideas for language that you can include in your agreements and some negotiating tips that are going to help to bring you to a mutual agreement as quickly as possible during this process.
And with that, what we thought that we would do is start with some overviews of the primary goals of the different parties to the agreement, because it helps to have those in mind when you're doing your contract review and negotiation. So, for example, usually the goals of the two parties are somewhat different. The sponsor and the CRO are particularly concerned about the data that's collected during the study to ensure that good, accurate data is collected to support the FDA applications. There's also an interest in protecting any confidential information and intellectual property that's provided to the institution and the investigator, and to make sure that everything gets conducted in compliance with all of the laws and regulations, so that the application doesn't hit a snag in the process. And then the institution and investigator also have some primary goals, such as to make sure that they're properly and fairly compensated for the work and the risk that they're taking in the process of the trial. Also to ensure that the site and the personnel that are working on the clinical trial are indemnified and protected from potential lawsuits, recovery of costs for subject injuries, and in some instances, depending on the site where the study is taking place, rights to publish the results. So we wanted to make sure that we pointed out that the time and effort that's spent on reviewing the contract up front is a good investment because it helps you to make sure that you meet all of the necessary activities that you need to do as you're putting your contract and your study together. What does the contract offer you? Why do you want to spend the time? Well, it gives you protection. And the protection takes a number of different forms. For example, you and the other side will have a clear understanding of what you're agreeing to, whichever party you happen to represent, and what you'll be paid to do. And in addition to that, it'll address important issues related to your responsibility and liability. So anyone who picks up the contract should be able to understand what you've agreed to and when you're going to do those various activities. You could think about it as, if my boss picked up this contract, would my boss understand what I've committed us to? And maybe not such a positive thought, but and hopefully it won't happen, but if the judge picks up this agreement, will the judge understand what we've agreed to and be able to say what's promised and what's beyond the promise?
So one of the things you want to watch out for is some common language traps that you're going to come across in reviewing contracts. As Marilyn mentioned, it's worth your time and effort to review a contract, so you need to be alert to these tricky things that you might see. So some of the suggestions we have is that, first of all, you should be looking at a contract not only from the lens of your perspective in the site, but from an outsider. What do the words actually mean? So if you come across language that says any and all or without limitation, we suggest that you be very careful about that type of language because it is very broad and general. For example, if you agree to language that says that the sponsor CRO can come in and look at any and all of your records, they're able to come in, when they come in for an audit, they might be able to come in, may ask for your employment records for all of your employees. And really my question would be is, do you want them to be looking at everyone's employment records? Is there a need for them to be looking at those types of documents? The alternative would be that we would suggest is listing out as specific as you can what type of records or whatever the language is surrounding the in the contract, list out the specifics of what they have access to. Another item that you will see quite often in my review of contracts that I do on behalf of our network participants is the term immediately. When you interpret immediately, it essentially means you have to drop everything right at that moment and take care of whatever activity you're required to do. We choose to change that term to promptly. It gives you a little more leeway from the perspective of when you have to notify, let's say, a sponsor CRO as it relates to a serious adverse event. Can you imagine dealing with a serious condition and knowing that immediately you need to notify the sponsor CRO? Technically, under the terms of the contract, if it says immediately, you theoretically have to drop what you're doing with that adverse event to go notify the sponsor CRO. Now, will a sponsor CRO hold you to that level of a standard? Maybe not, but is that a risk you're willing to take? That's why we would suggest trying to use terms such as promptly. Another example is best efforts versus reasonable efforts. Do you have to go above and beyond? And who gets to decide what is deemed best efforts versus reasonable efforts? What about sole discretion versus reasonable discretion? Can a sponsor CRO just basically willy-nilly decide to do something versus having a reasonable expectation of that decision being a reasonable decision being made under the contract? So you often are, I'm sure, experienced in knowing that you're going to receive template contracts from whatever party that you're working with. And as you read through them, you're going to notice that the voice of that contract is different depending upon who created it. So here's an example of a CRO type of language, as our screen is kind of going slowly here for some reason. Some language that you would see in a contract that a CRO has written that document. The focus is on what they shall be doing, what their obligations are, and it's written to the site, to the perspective of what they want and what they desire. Now, an alternative to that would be a sponsor language. And so here's an example of how a sponsor might draft some language of saying how all of the invoices must contain the sufficient details and what they expect and what they will do in a particular circumstance. Basically, the general rule when you're dealing with contracts is that the drafter of that contract template is going to write to his or her own advantage. Capitalized terms throughout a document are going to mean something. And you need to be very careful when you're reviewing a contract to make sure that if there's a term capitalized, is it defined, first of all, and is that term used consistently in a contract? I can tell you, for example, this morning I was reviewing a contract, and throughout the contract, all of a sudden there were all these different terms being referred to that in no way had been defined and were being used interchangeably to refer to different parties. That's something you want to make sure that you're very clear about. Who are all of the parties and what those capitalized terms mean, and are they used consistently? Anytime you're not sure about something in a contract, ask for clarification. Ask what the intent is by the drafter so that you know clearly what it is that's being expected. And know that the language of a contract can be what we refer to as very legalese or very plain language. So Marilyn has some examples for us.
Yes, we thought you might find it interesting to take a look at a couple of different contract sections that both address the same topic from two different authors. So the first one, if you are familiar with the reading evaluation, the reading level evaluations, this particular reading sample scores out at the 35th grade, and it's very complicated to read. So if you know the subject and you know the topic, it might be fairly clear to you, but it's not the most understandable wording that you might be able to imagine. So just take that in comparison with the next slide that we've got here, which is the same topic that covers the same requirement for the financial reporting or financial disclosure, but this is written in a somewhat more plain English style. It's still at the 30th grade level, so it's still complicated reading. I wouldn't give it to my first grader, but it is a little bit easier to read. And those two examples are just sort of to illustrate that when something's not completely clear to you and you need to have a better understanding of what's being required of you, you should ask for clarification. And then to the extent possible, you should make sure that you build in your best understanding of what that requirement is right into the contract, so everybody will be able to tell plainly by going back to that language what's expected. So here's some suggestions. It might be that as you are working with contracts going forward, you'll find that you are able to negotiate a provision that you're pretty happy with and you think that it's clear and it's reasonable. You might want to keep a copy of that, just drop a copy of it in a folder and reuse it in the future. Use it as perhaps a response to a provision that you're not understanding or that you think is onerous for your particular party that you're representing. It might help you to speed up your review process. Here are a couple of examples that we found that we thought that you might be able to use. One is a notice provision and has to do with monitoring and so forth. And the other example is language that you can use that would make an exception for medically necessary or emergency deviations from the protocol so that you wouldn't be considered in breach of a contract because you deviated when the reason that the deviation occurred was because of some sort of a medical situation. Next thing that we wanted to talk about was the actual contract sections themselves. we wanted to take the contract apart, talk about it piece by piece, and look at the various sections to try and highlight some of the things to think about. So the first thing that we wanted to talk about in the contract is the introductory portion, which is the part that describes who the parties are. And the thought that we had here is that you would want to look to make sure that the parties are correctly named, the entities are correctly named. Some of the clients that we work with have multiple sites or different DBAs, and you want to make sure that you've actually got the right party identified in your contract so that you know who's committing to promise all of the promises in the contract. Also, another thing that you'll want to do is decide and have maybe a policy about whether or not the investigator is going to be a party to the contract, or whether that investigator is going to read the contract and acknowledge that they understand they're responsible for some of the activities, many of the activities within the contract. Then there will be a section that will be what we refer to as the recitals, which generally tell you more about the parties and the background behind the agreement, but it really shouldn't include actual obligations of the various parties. And you might find sometimes that there will be obligations listed in there, but if there are, you'll want to check to make sure that they're within the body of the contract as well. You don't necessarily have to move them, but you should make sure that they're actually listed within the body of the contract. And then the other thing that we wanted to call out was that definitions get handled different ways in different contracts. So sometimes they show up as a unique section and all of the definitions should be there. Sometimes they are actually embedded right into the agreement. So neither one of those is right or wrong. It's sort of a matter of style. It's just a matter of making sure that if it's a separate section, that really the key definitions are all included there. There's pros and cons to using the two different types of styles of definitions. For example, if you've got the definition section, the good thing is everything's going to show up right there, so you always know where to go to look for the info. On the other hand, it means you have to flip back a couple pages if you've got a 20-page contract and something doesn't get used for the first time until the 16th page. On the other hand, the definitions being embedded into the agreement help you with context because you're actually seeing it used for the first time, but on the other hand, you won't necessarily be able to find it unless you do a sort of a computer search looking for the term. So sometimes that's more complicated. Next section of the contract that we wanted to talk about was probably the most important thing in terms of how the trial is going to take place, and that is the section that we refer to as the conduct of the trial. It's not always called that in your contract, but that's basically what the section discusses. So it's going to have information about what the investigator's responsibilities are, such as to perform the study, supervise the staff that are working on the study, follow the protocol. So what you want to look for in here is whether or not there are any requirements that don't apply to this study, for example. In my experience, this is usually one of the more straightforward sections, but you want to make sure that what's written in this section is what you're expecting and that you can actually deliver what you're committing to.
So continuing with the conduct of the trial, and you're going to find that there's multiple parts to this section of the contract, is the commitment to the study. This is a very typical provision in contracts, and it's just outlining the fact that the parties to the contract, typically the institution and the investigator, will not, during that term of that contract, participate in other studies, which by their nature are going to prevent them from fulfilling any of the obligations hereunder. Essentially, you're agreeing to make sure that you're giving the effort that you can to the study you're contracting on, and not diverting your attention to other studies that might conflict with it.
So also in the conduct of the trial section of the contract, you're going to find requirements associated with the monitoring activities, such as by the FDA or the regulating agency, the sponsor, the CRO, possibly others. So something to think about here is, do you need to build into your budget plan amounts of money that will allow you to monitor the monitors? For example, is your electronic health record segregated so that the people who are given access to your records can't fish around and look at things that they're not entitled to look at? Are you going to be handling just paper files, and do you need to make copies? Those are the kinds of things that you need to be aware of, mostly because you want to make sure that you've got the staff to do it, and also to make sure that if you need to build in budget money to cover those expenses, that you wind up having those expenses covered. And, excuse me, another part of the conduct of the trial is the reporting requirements, such as are monitors going to be visiting? Are there going to be reports required, like for adverse events, for sending the CRFs? And is it going to be the governing agency that's potentially going to be stopping by? Do you have to be prepared to handle that? Is the sponsor going to come if the agency comes? And so forth. And this is all tied back to what you will want to be building into your budget as well. So here's an example of some contract language that deals with adverse experience reporting. There's another section of the conduct of the trial that talks about disclosures. So debarment is one that comes up quite often, and from my perspective, a lot of times requires some further negotiation in order to ensure that there's not more information collected than what is absolutely essential, necessary, appropriate for the study. Might also involve high costs. So for example, here's a contract provision that requires that the institution would, upon knowledge of the starting of any proceedings, that's any proceedings at all, that could result in any of the institution or principal investigator being debarred, disqualified, or excluded. And this relates to any study, not just the study that's the subject of this contract. So that is an example of some very broad language. And it may be broader than what your institution is willing to disclose. And I guess the thought process I have is that the language that talks about could result doesn't necessarily mean that it will result, and may not affect the study, and should just sort of be thought through before you're willing to disclose those sorts of things. And my feeling is that you have to evaluate what your risk tolerance is in terms of potential impact on reputation and so forth. Sometimes those investigations or proceedings do not turn out to be debarment or disqualification. So you might want to limit that sort of disclosure.
So one of the items that you're going to find is language related to compliance with applicable laws. I would just suggest that you certainly pay attention to this area of the contract so that you know exactly what legal requirements you are agreeing to. Are there some laws that are being mentioned that maybe don't apply specifically to research that somehow got put into that contract? So pay very close attention to that type of language. You're also going to see language related to making sure as an institution that you have detailed, accurate, and timely record keeping. And this could have a trickle-down effect on your site, because as you see the language here that we've listed is that you have to have accurate and complete data submission, and those are necessary to ensure payment. So if your site does not submit the information in an accurate manner or on a timely manner, it is possible that you may lose some of your funding, which you certainly don't want to have occur. Another piece of tidbit that we can give you here is certainly to watch for time tables that are put into the contract as it relates to how quickly you have to enter data, let's say after a visit. Does it have to be done within 24 hours, 48 hours, 5 days, 3 days? What is that time frame, and can you commit to that? You need to be talking with your team to make sure that those expectations can be met, or if you have to ask for something else. So remember to limit also the number of years you must keep records in storage post-study closure to that which is minimally required by law. I oftentimes see where they've asked for records to be kept for 15 years. And that really is just a huge, very long period of time. And you have to make sure that for wherever you are located, is that appropriate? And you want to make sure that you are having to keep them just for what's minimally necessary. And we suggest that you always request that the sponsor pay for record storage, any return of records, and or destruction, because those are all efforts you have to do on behalf of the study, and therefore it's something that the sponsor should have to pay for. So here's some language that we rely upon oftentimes in our contract negotiations with our clients to see that we make sure and keep the records at the sponsor's expense, as you see there in red, for the longer of, whether it be 2 years following completion of the study, 2 years after termination or withdrawal of the health regulatory agency exemption, or the period required by local, state, and federal laws, regulations, and FDA guidance. Then we include language that relates to the actual destruction or termination of those records and what's going to happen, whether it's going to be at the sponsor's option, and should they be delivered to the sponsor and let them then deal with them, retain the records for a mutually agreeable time, or dispose of those records according to how the sponsor wants them disposed of, provided, however, that the sponsor is going to pay the costs associated with that effort. Now, another section that you're going to come across in the actual body of the contract is in regard to payments. What I would suggest here is you are going to want to make sure that the information in your body of your contract is likely to be limited about the payments. Usually it's going to be general terms, and in the exhibit or as an attachment to the contract is really where the guts of the payment terms are going to be. One tricky part, however, is the fact that you need to make sure that both sections are consistent. You don't want to have them contradicting themselves at all. In the payment section, you're also going to see language usually related to fair market value statements, and that payments cannot be inducements to refer or purchase goods or services. The anti-kickback regulations. So here's an example of some language that we oftentimes see, and what we've done here is that typically it's going to say that it represents fair market value. Now, you as an institution may not know what fair market value actually is for conducting that trial. However, you know what your site needs in order, from a cost perspective, in order to conduct the study. And so we oftentimes suggest that the language be changed to say represents fair compensation for the conduct of the study, because it's the compensation that you need in order to perform that particular study. Now, this also we have some examples here of language as it relates to the anti-kickback for making sure that payment is not inducements for referrals of actual activity, further activity with the sponsor. So a couple contract tips for you. If possible, the same person should review the contract and payment term language as it's going to provide for that consistency. As I mentioned when I mentioned about the payment terms, if the guts of the payment terms are going to be an exhibit, but there is some mention in the body of the contract, you want those to be not contradict each other. And so it's usually very important to have the same person reviewing those two types of documents, or even working with the budget. And Marilyn, I think you have an example of this that you wanted to share.
Yes, just in the last week or so, just as an example, we were working on sort of on two parallel tracks, a budget and a contract. And as it happened, the budget finished up a few hours before the contract did. And unfortunately, the language that we were requesting in the contract was accepted and agreed to, and the sponsor in this particular instance said, sure, just put it in the budget. But as it happened, the budget finished before the contract negotiation did. So we were in a position where we had to either go back and reopen the budget to add that term in, or to go back to the contract language and say, well, could we just add it in here instead? That'll be covered, that'll be invoiceable, or it'll be a payable expense by the sponsor. So that's an illustration of Jill's point that sometimes it's helpful to have those kinds of things happening with the same person so that you can catch that and keep it consistent between the various attachments.
The next item you might be thinking it's a no-brainer, but it's important to mention that you should request the most advantageous payment terms for your site. You have to, again, go into the negotiation process, the contracting process, from the perspective of what you need and what's going to protect you and what's going to meet your expectations. Certainly be sensitive to payments being tied to review of CRFs by sponsors or CROs. I will, on behalf of our network participating sites, when we're reviewing and negotiating contracts, I'm asking for the sponsor and CRO to also commit and have an obligation to complete their reviews in a timely manner. You don't want to have their workload or any issues at the sponsor CRO side holding up your payment, which is typically what you're going to see in that situation.
So another section of the contract that you'll want to take a look at is the section that governs confidential information and intellectual property. Generally speaking, we have the sponsor trying to protect as much as possible about the study, which might be the device or the drug, and the process and the invention and the results, while the institutions typically want to protect their intellectual property that they owned before the study, the subject PHI, the informed consent, authorizations, and so forth. So depending on which party you're representing, what do you want that language to say? What is the limit that you need to impose? What is the ability to use that information? How are you going to approach that? And how are you going to determine what's acceptable to you? So does your institution or investigator want the right to publish? That's generally not what I see in the template contracts that come through. So you'll want to have to build that information in. And then the next thing to think about is how long is your obligation to protect? In a contract that I was just working on this morning, there was a permanent confidentiality requirement, which is even longer than 15 years. So it's really a long time, and it's hard to explain why it would need to be a permanent obligation. So look for those kinds of things to protect yourself. Next thing we wanted to just highlight is some releases, some language for releases that are required by law. Make sure that you allow yourself the ability to release information if you are being requested to do so by a governing agency or a court. And here is an example of some language that we find helpful and acceptable that you might be able to use as well. And then we want to move on to the next section of the contract, which has to do with indemnification and insurance. This is the section that talks about who's going to be liable for what sorts of difficulties that might come up. And you always hope that you don't have a situation that needs to be dealt with, but really the reason that you're putting this language in the contract is to protect yourself in those instances when it does come up. So this is the section of the contract that's going to talk about who protects whom when an issue arises. The sponsor or the CRO or both, indemnifying the institution and the investigator, the institution indemnifying the sponsor, and then why, under what circumstances are you going to be protecting each other from difficulties that come up. Jill and I put in sort of in the highlighter color here to be really careful when you're looking at this language. You need to do a little background investigation, find out what your employer, your insurance plan allows you to agree to when it comes to indemnification, because sometimes insurance provisions, insurance coverage can be voided if you agree to indemnify another party in a contract. So you want to know that going in so that you can build in the correct language.
So from the perspective of the site, which I want to make sure it's clear that that's the view that I take, oftentimes with contracts, because I'm working with our network participants, we want to make sure that your site is indemnified under all of the following circumstances. Subject illness, death, or injury is a key one, obviously. But we also want you to be protected, or we feel that you should be protected under the sponsor's failure to comply with any applicable FDA or governmental regulations, sponsor's negligence, omissions, recklessness, or willful misconduct, their breach of representations, warranties, or obligations, and sponsor's use of data and study results. So in this particular instance, I also want to recommend that not only do you approach indemnification language from the perspective of the sponsor's failure to do any of these activities, but also a CRO. Don't forget about them. Don't forget about any sponsor's designee. You also want to be protected under any of those circumstances as well. So I want to give you an example of a contract I worked on. Here's the original language that the sponsor provided as far as their obligation to indemnify. And I'm going to quickly read through here, or you can quickly read through actually, but all we were going to indemnify the institution against was any claims that were caused by the use of the study drug during the course of the study. Now, in this case, we objected to this information. Our feedback to the sponsor on behalf of the institution was to ask for all of the prior items that we mentioned. And when the sponsor came back to us, essentially what their second offer of language was, is that they agreed to provide indemnification for the use of the study drugs, but also we included any intervention or procedures provided for or required by the protocol. But they also then, and they agreed to that, but then the only other thing they said they would agree to was the sponsor's or its designee's use of the study data or results. So of course, what I did is I pushed back on this because, again, this does not provide enough protection for the institution should something happen. And again, as Marilyn said, we don't want it to happen, but in the case that it does, it may not be a probability, but it's a possibility that you want to insure against. And so in the end, this is the language that we agreed to. So we essentially got everything that we wanted. It did take some going back and forth. However, the sites were protected from the perspective of not only the study drug and the procedures or intervention required by the protocol, but from any claims that resulted from the sponsor's breach of the material terms of the agreement or their failure to comply with applicable law, arising from the sponsor's negligent acts or omissions or willful misconduct, as well as the sponsor or designated use of the study data or results. So in the end, we got everything that we essentially started asking for.
Next thing that we wanted to talk about are a couple of things to look at while you're still in this indemnification and insurance provision. For example, who's going to control the defense of the claim? If you are sued, are you going to turn over the defense of your lawsuit to the other party so that they decide, they have the lawyers, they decide the court dates, they basically can take it all the way up to settlement and so forth. So know if that's important for you to control the defense of the claim that you need to add that language in there, allowing yourself that right. Then if you're going to assist the sponsor or the CRO in defending a claim, make sure that you request compensation for that. So if you are involved in litigation, that can be very time-consuming, and you'll want to make sure that your reasonable costs are reimbursed for the time that you spend looking for records and attending court sessions and depositions and meetings and so on and so forth. That's a lot of time for you to be taken away from the study and putting staff on. Another thing we really like to look for is what sort of notification requirements are there in the event that there's a lawsuit. A lot of times there's a requirement for immediate notification. Sometimes it's notification within a week, or in one instance I can remember seeing a requirement that the notice go to the other party within 30 days. The thing that we want to call out here is that if you fail for some reason, forget, or are late in giving notice of that claim, please make sure that you add in language that says if it doesn't materially prejudice the case, that it won't void your indemnification provision. In other words, you can still be protected as long as your delay or failure to give notice didn't cause any harm. And here's an example. Let's see. I'll have an example coming up for you of that language too. Insurance language should be requested. So you can have very specific language. You might want to consider more specific, like 1 million, 3 million, 1 million, 5 million type of coverage. If you're working with an unfamiliar entity, maybe you're working for a sponsor that you haven't worked with before, you're not sure about their background and history, or likewise the other side could apply to, that you want to make sure that you have some very specific information. But this is information that we use that is just general, but it also covers the need.
One of the key factors of a contract is what is the term of that contract? How long is the contracted period? Typically what we're going to see is that language is going to be referred to either until the end of the study or until earlier terminated. These are pretty basic options that are available in a particular study contract. But you also want to pay attention to what is the effective date, and that it's expressed clearly in the contract. So generally what you're going to see one of two options. Either it's going to be specifically stated, such as this example here, that it states on a particular date and that's the effective date. But you also may see something a little more general that says that the agreement is going to start on the latest date that has been signed by either party. Neither one of these are wrong. They're both okay. It's just the key factor here is that it's actually expressed and it's clearly understood by all of the parties to the contract. Now, contract termination, and you're usually going to see contract term and contract termination together as one section of a contract. Termination should be by any party. You as a site, in my opinion, want to be able to terminate a contract as well. I strongly suggest that you do not let just the sponsor and or CRO be the only party that can terminate the contract. You want to pay attention to when does the party get to terminate? Is it effective immediately? Is it after a number of days following notification? And who's going to receive the notice? Is it going to be the institution, the investigator, or both? One key point here is if it's the investigator only, you as the institution should make sure that your investigator is going to pass that information along to you as the institution. Now, these are some sponsor and CRO reasons for termination, which typically vary, but usually you're going to see language talking about with or without cause, if the investigator is unavailable, breach. There's just going to be a number of different opportunities under which the sponsor or CRO can terminate. You likely will see some language that just says that they get to terminate regardless. If they wanted to terminate, they can. I typically don't fight that type of language at all because they do have the right to do that. However, what I pursue then on behalf of our site is that they don't leave their termination rights to chance. They need to be protected. And so when we're looking at a contract, or I'm reviewing a contract, I'm going to be looking for language to be included that allows the site to terminate if they're requested to do so by the IRB, if the investigator is no longer available, under circumstances to protect the health and safety of the subject, breach of the contract without cure. One key one that we always include is bankruptcy, insolvency, or ceasing to carry out business by the sponsor or CRO. To me, this is very, very important. You as a site want to make sure that if a sponsor CRO suddenly is unable to pay the bills, that you're able to terminate that contract. If you didn't have that right, you would be stuck in that contract and potentially could be in a situation where you're obligated to continue to do the study without payment. And certainly any exclusion from any state or federal governmental program. So here is some language that we typically do use. Again, as I mentioned earlier with the indemnification, we want to make sure that you point out that the termination is if the sponsor or its designee or the CRO is in breach of the contract or becomes bankrupt. You don't want to just leave it to the sponsor because you have other parties that are involved in representing the sponsor. A few other contract termination tips. As a site institution, I would strongly suggest that you establish some standard reasons that your site would want to terminate. Marilyn mentioned earlier about having contract template language that you like. This is a great section that if you come across language, you've developed language that you really find that it covers your needs, use it and reuse it as you're going through contract reviews. Prioritize your list of your standard reasons so that you get those which are most important to you. Again, be sure to cover termination notices, who it should go to. You want to try to secure favorable language regarding payment following early termination. One thing that we also do is that we always want to address costs to remove subjects from the study when termination occurs before the study is actually completed. There may be costs that you have incurred to remove those subjects, and you want to have those expenses covered.
So we are closing in toward the end sections of the contract, but I wanted to make sure that I pointed out that the sort of miscellaneous areas at the end of the contract that sometimes people call boilerplate or just all the rest of that legal jazz, that's something that's actually still worth reviewing and reading through and making sure that there's nothing in there that you can't live with. So for example, with governing law, are you going to have to traipse all the way across the country if there happens to be a lawsuit or a concern? You can suggest either being silent on that governing law, or you can put in your own state if you're a smaller or local entity so that you don't have to spend the money to go across country or whatever in order to get your concerns resolved. In terms of force majeure, this is something that you just want to look and make sure that the things that, if there's something called out that's sort of a natural force that's beyond human control that causes you not to be able to perform, such as Katrina or something like that, make sure that what's listed in there is actually going to be something that will be applicable to your area. So just not to make total light of it, but if you are an institution in Iowa and the only reason that you'll be permitted, the only act of nature that you'll be permitted to stop operations for and not be in breach of a contract is a volcano, that's not going to help you very much. So make sure that you look at that kind of thing for applicability to your area and build in what makes sense. In terms of mergers and assignments, you really can't stop the contract. Typically, you can't stop the contract for mergers or for assignments. What you can request, though, are two things. One is courtesy notice of such an event so that you know who the parties are going to be. The other thing is to say if this, the duties of one or the other party gets assigned to someone else, that the original contracting party remains responsible to you for completing their duties so that you still have some leverage there. In terms of notice, just make sure that you're being mindful of what the requirements are. If you feel more comfortable with email notice, that the requirement is for a courier or a personal hand delivery, you need to be aware of that. For arbitration, this is really something that was initially considered to be more timely than going through the court system and maybe more affordable. I don't know that that's necessarily true anymore, but just be familiar with what the requirements are. In terms of entire agreements and amendments, I've seen a number of contracts come across my desk that call it the entire agreement, but then they don't include any of the attachments or amendments. So look for that kind of thing because you'll want the protocol to be part of the agreement and the budget. And finally, the severability provision. Laws change, court cases change the way that things are handled. So the language in the severability section allows the rest of the contract to be valid even if a particular section becomes invalid due to some change in the law.
So we've thrown a lot of information at you, provided you with a number of different sample language. So we want to just kind of wrap back up here and talk about the fact that throughout this whole process, really you're doing a lot of negotiating. And so we can't emphasize more that it is really critical that you prioritize. Really know when you're reviewing a contract, what are the main key points that you as a site or whomever, whatever type of contract you're reviewing, it may not even be in relation to a study. It might be a contract for a lease. It might be a contract that you're dealing with for buying a car, whatever it may be, that you know what exact things are the top priorities you have of the language you want to get into that contract. And certainly do not go into the process with your bottom line offer. You know, as you're going to know that when you're doing, let's say for an example, a budget, the budget's going to come in typically low from the first offer that you're going to get, and you're going to go back and forth and meet someplace in the middle. So the same thing applies when you're going through the contract language. Go in asking for more than what you expect you're going to get. It never hurts to ask by any means, but just prepared to be able to compromise and know that you're not going to get everything that you want. And always have supporting justification available so that if the sponsor CRO asks you why you have to have a particular language, make sure that you have reasoning behind that and that you know what it is that you have that you can provide to them to justify your request. Don't delay contract feedback. And I know that that sounds very easy, and trust me, I know on a day-to-day basis it can be very difficult to squeeze everything in. But really, understand that from your own perspective, the faster you can get your response back, the better. It's going to, in the end, it's going to make your site have more of a positive impression upon a sponsor CRO. The faster you can get your documents in and get through the negotiating process, the more they're going to think in the future, hey, you know, working with this site was really easy. You know, they were really fast in getting everything back to us. On the flip side of the coin, understand, though, that, you know, the response from the sponsor CRO may not be as timely as your efforts have been. And you really have to just focus on your own turnaround times and not so much about the sponsor CRO. Now, certainly don't forget that you have something pending. Don't necessarily, though, be a pest in trying to get information out of the sponsor CRO. Typically what I've seen is that, you know, the more timely you are, the more likelihood or the greater the chance that you're going to get what you want in that particular contract. So in addition, another tip that we would provide for you is that make sure you have version control of your documents. Do you as an institution or as a company have a standard naming convention? And saving versions of your contracts and documents that are going back and forth, because typically there's going to be a number of documents coming back and forth. And just to kind of give you an idea, what we do here is that we're going to, when I first get a particular contract, it's going to come in and I'm going to name it that it's the sponsor CTA, it's version 1, I'm going to make sure that the protocol name is included, what investigators I'm working with, and the dates of that particular document. And then what I'm going to do is I'm going to provide them a document back that I'm going to include the term feed document so that I know version 1 was what I got from the sponsor CRO. Version 1 with feedback is what I provided. And then when I get something back from them, I'm going to then name it version 2 so that I know as I'm going through exactly what it is, what version I'm working with, what was the last document that was the item that we were reviewing. Again, too, I would also mention that when you get the final document for signature, before signing that, I always go back and review that to my last known agreed upon document to make sure that nothing got changed at the very end. You want to make sure everything is there. I have experienced that someone used the wrong version from the sponsor. Maybe they somebody else was helping an individual out, and suddenly I got this completely different contract version, or some language we had agreed to was no longer in there. And so I always go back and review that to make sure that it's the absolute correct version that we want to be, that we've agreed to and that we'll be signing. Bottom line is negotiating. It's all about communication and compromise. It's a two-way street, but ultimately you have to realize that and understand that what you are agreeing to is legally binding on all the parties once it's executed. You have a contractual obligation when that document is executed. That is what you are agreeing to do, and that's what you're going to be held to as far as the standard is concerned.
And with that, I just, on behalf of Jill and me, I'd like to thank you so much for listening this afternoon. I hope that you got some good tips for clinical trial agreements and ideas for what to focus on, some specific language that you might be able to use or modify for your own preference, and some ideas for how to negotiate your contracts as quickly as possible. So thank you this afternoon.
Unmuted.
For your help and your concentration, and are looking forward to your questions.
And know that we will be available here for, I know we went over a little bit than what we wanted to from availability for questions, but certainly we open it up for questions.
Thanks, Jill and Marilyn, for that excellent presentation. Now we'll move to the question-answer portion. And the first question, in the readability example, the term accurate was used. Do you typically allow the use of the term throughout a clinical trial agreement? Is the term accurate something that you would typically define? We see the term used a lot for describing completion of data on case report forms. And how would you answer something like that?
So that's an excellent question. And I would say that...
Muted. Unmuted.
Sorry, we're getting a little feedback on this end. I would say that generally I would allow the word accurate when I'm looking at accurate completion. And if necessary, or if that's been an issue for a particular sponsor or site, then I would ask for a definition of what's considered to be accurate.
Hey, Jill and Marilyn, would you be able to stay a little bit longer for a couple more questions, or would you have to go now?
No, we're available.
We have one more question. Can you suggest this sponsor put all the payment information in the budget and have none within the body of the agreement?
My preference is that, yes, the actual, what I'm going to refer to as the guts of the payment terms be as an attachment, whether it be included in the actual budget grid or the budget grid combined with a payment terms document. As far as in the actual contract itself, typically what I see and what I prefer is to have this very basic general language where it's going to cite the fact that the sponsor or CRO is going to be paying the institution and just the general information about fair compensation and the anti-kickback. And there typically would be just a reference to, in that language, is to be some reference to the exhibit or the attachments of the budget as far as for the specific payment term.
Okay, another question, can you address adding language to the agreement regarding stopping or temporarily halting enrollment, which is not typically addressed? Instead of agreements, only address complete termination of the study.
I'm thinking that I have seen one or two agreements that include language to that effect, and it's something to the effect of temporary suspensions based on a particular called-out time frame. So it would be something like the sponsor reserves the right to suspend enrollment for a period of, I don't know, 10 days or 2 weeks or whatever the time period is. with a certain amount of prior advance notice. And in one instance that I can think of, there was also an explanation of what circumstances would have to be in place before a sponsor would suspend enrollment.
Another question regarding the fair compensation versus FMV. We find it advantageous to keep FMV in the contract language as if it makes it easier to get similar pricing through FMV analysis in future budget negotiations with the same sponsor. Any thoughts on that?
I think that that's very true, that having some language, it does give you an advantage down the road. The approach, though, that we mentioned that we take is to refer to it as fair compensation as opposed to fair market value. The fair market value, the connotation with that is that it's a fair payment across the whole market. And certainly some institutions that maybe are located in California or in Manhattan, they're going to have a lot higher expenses than other sites might have that might be located, let's say, in North Dakota or Iowa or maybe even Alabama. It just all depends. So that's why we prefer going with fair compensation, which still allows you that flexibility to use that budget type of information later on in future experiences with that sponsor or CRO.
A new question, what about termination for slow or late payment?
I have actually drafted contracts with that sort of language that that says that the institution has the right to terminate the contract in the event that there is slow compensation from the sponsor. In some cases, you don't need that language because you can have that defined as a breach of the contract. If the contract term says that payments will be made, I don't know, 30 days or 60 days or whatever the term, the length of time is, and if the sponsor doesn't pay in that amount of time, you get the sponsor notice they're in breach, and then if they still don't cure, then you terminate. So that's two ways that you can handle that situation.
And I also want to piggyback on that as far as from the perspective of if you're encountering a situation where the sponsor or CRO, whoever the paying entity is, has an obligation under the contract to pay in a certain time period, you should be making sure that you have someone monitoring that. And that if the sponsor or CRO is repeatedly not meeting that expectation, that indeed you are going back to them and saying, this is in breach of your contract, and approaching it from the perspective that, hey, sponsor CRO, you have an obligation to us. You have a contractual obligation to pay us within this time period, and, we can put forth that argument of breach of the contract. So always make sure that you're watching that or have somebody kind of keeping an eye on that. And I wouldn't necessarily say approach a sponsor CRO after the first time. But if it's a repeated problem, that is something that you can certainly put forth to the sponsor CRO.
New question, do you have examples of costs to remove subjects following early termination of the study?
Well, I think it all depends upon the particular study. And so you need to be sensitive to what the particular study is and what efforts have to be taken in order to remove them. It may be a cost associated with transferring them to another site. As a matter of fact, I'm working with someone right now who the individual relocated to another state, and so they're going to be moving to a different study site in the study. And so the current institution needs to work with the new institution in providing them all of the documentation and all of the information related to that individual. And so those are additional costs that the sponsor CRO should be responsible for when a situation arises.
What suggestions do you have to address late payment of fees due sites for work performed?
Oh, that's a great one. One suggestion that I have is that including information in the contract, typically in the payment terms section, whether it's in attachments or the body, wherever it's going to be talking about when payments are due, is to include any language about, that there will be a penalty to the sponsored CRO if payment is not rendered in the time frame that it's being agreed upon.
It's best if you can state that in terms of an interest payment, for example.
Right.
New question, should a site have an SOP for contracts?
Well, I personally think that's a good idea because that way you have, for example, a checklist. It may be a certain number of people that need to review the contract or sign off on it. It may have to do with, say you'll have authority to sign a contract by a manager up to a certain dollar value of the contract, but then after a certain point that it needs to go to a director or a vice president or a CEO, depending on the level of commitment that that party is responsible for. So I think it's a great idea. Of course, once you have a standard operating procedure, then you have to follow it. So it's a little bit of a, it's like a policy and procedure. Once you've got it written down, that's what you have to do. But I do think it's a really good idea because it helps you avoid misses.
Well, I think, too, that I agree with Marilyn, and I think some of the things that you want to focus on in the standard operating procedure is from the perspective of your site. As Marilyn mentioned, who has the authority to sign and at what levels. And the other thing that I think of oftentimes is the turnaround. How once you receive a template, how quickly is that template going to be turned around as far as the review, so that you have some degree of expectation within your organization as to what you're going to do. Now, again, this can be a double-edged sword, that if you're not following your procedures, what is that going to say about your institution? One thing is that maybe your expectations are unrealistic and you need to change them, or maybe you need more staff. So it can cause you pros and cons, but at least it's a framework within to work. Another thing that I've heard a few times is that, sometimes when sponsors or CROs are coming in for, let's say, a pre-study visit, it's kind of nice for them to know. They're typically going to ask, how long is it going to take you to review the contract and budget? And that way you can always show them your standard operating procedure as far as what the expectations are. But again, as Marilyn mentioned, you kind of then are going to be held to that standard.
New question, in reference to determining local regulations for long-term storage of the documents, what is the standard?
I can't think of a way to avoid having to look at the law. And Jill, maybe you've got inspiration on that point, but I think the best way to look at it is to see if there are certain local regulations related to that particular topic.
Yeah, that's exactly what I would say. I can tell you in Wisconsin, many records are required to be kept either 7 years, 10 years, or permanently. It just all depends upon the nature of the record. So it really is going to take some effort on the part of the site to know that in their state and in their local geographical area, what are the standards that they would be expected to keep that information.
New question, if a master agreement is in effect with a sponsor and new studies are added as they come in, how often is it recommended that the master agreement be reviewed?
I love that question. So there's a real kind of tension in deciding on what the time frame should be, and to some extent it's going to be the preference or the institutional policy to decide I want to review my master contract every so X long. So if you choose a really short time frame for a master agreement might be 3 years or 2 years, something like that. You put a lot of effort into pulling together a master agreement, and you kind of want to have it last a little bit longer than just a year, 2 years, 3 years. But on the other hand, when you agree to a really long, extensive term for a master agreement, it may be that your circumstances change a lot in 5 years or 7 years. You've committed to something that doesn't make sense for you 7 years down the line. So I guess my recommendation would be that you go with something on the shorter end and put the effort into doing the review at least every couple, 3 years, maybe 4 years, because things change so much. I mean, and the health industry is changing, as you all know. The health industry is changing so rapidly. The laws are changing so rapidly, it's hard to keep up. So it's best not to be totally committed to something for 10 years when the entire world could be different 10 years down the road.
Okay, just a few more questions. What is the best language for monthly payment contracts for late payment if the payment's received after the net 30-day late? Or how about reasonable administration fees for our collection efforts?
From my perspective, including a penalty and recovering costs for that is absolutely something that would be important to try to pursue. Because yes, if you have additional costs as a site to be trying to hunt down that payment. So it would typically be something to the extent, I think, of saying that payments are due as negotiated or as agreed upon or as stated above, and then something to the extent of saying that if payment is not received as agreed upon, there will be an interest fee applied to the balance due, as well as payment of any administrative costs associated to recover and pursue that payment.
Next question. Can you address the best language to incorporate into the contract for change of scope in work?
Ooh. Well, that's an excellent question. I guess what I would do is in your initial negotiation of the agreement, you would have, and not all agreements have this language, but I have seen instances in which there's a reference. I mean, everybody probably puts in language that says that this agreement can't be amended without the written agreement of the parties. So put something in there that says if the scope of the agreement changes to the extent that either party considers that their performance will be affected, that they would, in all good faith, renegotiate that term of that agreement or something to that effect. That's off the top of my head. I could probably cook up something a little more polished and smooth if I sat down and wrote it out, but something to that effect I would try.
All right, next question. What are the ethical considerations for contract negotiations between attorneys and those without a JD? For example, research site does not have the legal team directly handling clinical trial contracts.
Actually, I think that happens quite a lot. I believe that there are a lot of contract reviews that are done by non-attorneys. And of course, as a JD, I would always recommend that you go get a lawyer to look at it. But Jill, do you have any thoughts?
Well, I'm not an attorney, so I guess from my perspective, I think it really boils down to, if a site is having someone who's not an attorney, not a JD, that's doing the negotiation, that at least you should maybe be able to have a person that you can turn to and get some advice from if you don't understand something, or that you're just not sure if what you're being told is accurate. It's likely it's going to cost you something to have an attorney available to you, just as needed. But it certainly is a resource. I can tell you that I go to Marilyn with questions, and and actually Marilyn comes to me with questions, and we will talk them through together to try to resolve what other conflict that we have in trying to resolve some language issues.
Okay, and our last question, have you ever heard of an institution requiring the sponsor or CRO fill in a budget template prior to the institution reviewing the budget, similar to sending institutions contracting principles for inclusion in an agreement prior to institution's review?
I want to make sure I understood the question. So basically, if we ever encountered where a sponsor or CRO is asking the site to pre-negotiate a budget?
Yes.
Okay. As a matter of fact, yes, I know I have seen it. And typically where I've seen it is that basically the sponsor or CRO wants to make sure that they can come to an agreement on the contract and budget, in particular, especially the budget, before they actually select the site. It's not the typical process, but I have certainly seen it. Usually those negotiations are going to be covered under the CDA that likely has been signed up front in order to even share the contract, the study information, I should say, excuse me. So that's not totally unheard of. It is somewhat unusual, and in those cases, what I would strongly recommend is that the sponsor or CRO be put in a position to agree to make some sort of payment to the site in the event that the negotiations do not go all the way through to full execution or the site is not selected. Because you put in all of this time and effort up front without the in the chance that you're not going to be selected for the study. So
that wraps up our question and answer for today. Just a reminder that the slides will be sent out by email within 24 hours after today's presentation. Thank you, everyone, for attending the presentation. We hope you found it interesting and informative. And a big, again, thank you to Jill and Marilyn for presenting. Be sure to be on the lookout for the September installment of the Clinical Conductor webinar series. Thank you. Have a great day. Very well.